Breaking immigration developments are happening right now, and many people don't realize the impact yet. A partial shutdown at the Department of Homeland Security, leadership changes, and new enforcement concerns are creating uncertainty for visa applicants, green card holders, and even U.S. citizens connected to immigration cases. In this video, I'm going to explain what is really happening and what families should understand before their case is affected. As we're going to discuss today, friends, immigration is not only an issue that undocumented individuals in the United States are facing, and it is certainly not just a concern for people outside of the United States either. It is also something that can impact U.S. citizens. We'll talk about that shortly. Come in and type "Experience Matters" and type "Peace Matters." At McBean Law, our focus is on delivering quality, experienced legal services to clients nationwide. Although our office is located in White Plains, New York, you can contact us for a virtual consultation. We work with clients across all 50 states and also assist individuals in many different countries. We handle removal matters, complex family cases, consular cases, and many other immigration matters. We are a full-service immigration law firm. I see that everyone is on now. Thank you so much for joining me. You can reach us at 914-898-9488, or you can visit mcbeanlaw.com and submit a request to meet with us. We would be happy to schedule a consultation. I'm going to begin with some immigration news that I believe is important, and then we'll move into some updates about things happening here at McBean Law. There are some exciting developments, and afterward we'll move into the Q&A portion, which is usually the longest part of our session. Thank you for the gifts on TikTok. First, regarding immigration news, the Department of Homeland Security is currently experiencing a partial shutdown related to budget issues. Congress has been debating additional funding for DHS, and discussions have continued about oversight and operational concerns. Some lawmakers have stated that they want certain reforms and operational improvements before approving additional funding. As a result, DHS has remained in a partial shutdown period, now entering its fourth week after the Senate was unable to pass a funding bill. The vote on the most recent DHS funding measure was 51-45. On the Senate side, most Democrats voted against the measure, with Senator Fetterman of Pennsylvania being one exception. A total of 60 votes were required for the bill to pass. Negotiations are still continuing on Capitol Hill, with Senators Thune, Schumer, and others participating in discussions to reach a resolution. Second, another major development involves leadership changes at DHS. The Secretary of Homeland Security, Kristi Noem, has stepped down, and Senator Markwayne Mullin from Oklahoma has been nominated as the replacement. However, the Senate still needs to hold a confirmation vote before he can officially take the position. It is generally expected that the Senate will move forward with confirmation, as senators often approve nominees for cabinet-level roles. Senator Mullin previously served as a member of the House of Representatives from 2013 to 2023 before becoming a senator. He is also a member of the Cherokee Nation, making him the first tribal citizen in the Senate in nearly 2 decades. In addition, he has experience as a professional MMA fighter and previously operated a family plumbing business. If confirmed, he is expected to continue current immigration enforcement priorities and policy approaches. We will continue to monitor developments regarding his confirmation and policy direction. Now, let's discuss the broader point I mentioned earlier, that immigration policies can sometimes affect not only non-citizens, but also U.S. citizens in certain ways. The Wall Street Journal recently published an article discussing concerns raised by some individuals about enforcement activities and how those activities intersect with public protests and online speech. The article suggests that some citizens who have participated in protests or publicly criticized enforcement policies have reported interactions with authorities related to those activities. According to the article, some of these cases have raised questions about how enforcement agencies interact with individuals who express criticism or participate in demonstrations. It is important to note that U.S. citizens generally cannot be detained by immigration authorities for immigration violations, because immigration laws primarily apply to non-citizens. The article states that some of the reported cases did not result in prosecution, and that courts ultimately determine whether any legal action is appropriate. Another issue we are seeing from the administrative side of immigration practice involves policy decisions that can indirectly affect U.S. citizens who are petitioning for family members. I recently met with a married couple, for example, where the husband is a U.S. citizen and had filed a petition for his wife. The wife was otherwise eligible for the process, and their interview had been scheduled with USCIS. However, when they arrived, they were informed that the case could not move forward at that time, and that the application would be placed on hold due to broader policy guidance affecting cases connected to certain countries. In this example, the husband had been born in a country included in a list subject to additional review procedures. The wife herself was not from one of those countries, yet the case was still placed on hold. Situations like this can create confusion and frustration for families who are following the legal process and expecting their cases to move forward. Because of situations like this, our firm is preparing to challenge certain policies through litigation. We believe that clear and consistent rules are important for families navigating the immigration system. We are planning to file a lawsuit related to a policy that affects applicants connected to a list of 39 countries. We believe that policy raises serious concerns about fairness and consistency in adjudicating cases. In addition to that effort, we also have an update regarding another legal initiative. March 14 is the deadline to join our lawsuit related to an immigrant visa processing pause affecting applicants connected to 52 countries. We will share the link explaining how to begin the onboarding process for that lawsuit. The goal of the case is to request that the government resume processing immigrant visa cases so that qualified applicants can complete the process and receive their visas if they meet the legal requirements. On a lighter note, we also have a webinar scheduled for Friday the 13th. One of my colleagues from our firm will be joining me for a discussion about naturalization and the path to U.S. citizenship. The webinar will focus specifically on strategies for individuals seeking to become U.S. citizens. Registration is required, and we will share the Zoom link in the chat and on our social media stories so you can sign up. Now let's move into some of your immigration questions. Someone asked about a visa refusal with a 221G notice. In general, a 221G notice means that the embassy or consulate cannot issue the visa immediately and needs additional information or review before making a final decision. In many cases, the applicant must provide additional documents or the government may conduct further background checks. Sometimes it is simply a missing document that must be submitted before the case can proceed. Another question concerns the pause affecting immigrant visa issuance in certain countries. Currently, some applicants have experienced delays or refusals due to policy reviews and administrative processing. These pauses are often described as indefinite because the government has not announced a specific timeline for resuming full processing. Another person asked about options after receiving a deportation order following an unsuccessful appeal. In situations like this, the first step is to carefully review the individual's immigration history and the reasons for the removal order. In some cases, it may be possible to reopen the case or pursue other forms of relief, depending on the person's circumstances and eligibility under immigration law. Each case is different, and an experienced immigration attorney can evaluate whether there are options available. We also see many cases where individuals eventually find a pathway to resolve long-standing issues. For example, we recently worked with a client from Haiti whose case had been in immigration proceedings for many years. After carefully reviewing the record and filing a motion with the immigration court, we were able to obtain termination of the removal proceedings. That allowed the individual to continue pursuing permanent residence through a family petition filed by a U.S. citizen child. Another question concerns whether interviews are still being scheduled by the National Visa Center. In many cases, the NVC continues to schedule interviews, although the final outcome can depend on embassy processing policies and any applicable travel or visa restrictions. Someone asked about adjustment of status. In general, adjustment of status is available to individuals who were inspected and admitted or paroled into the United States and who have a qualifying petition, such as through a family member, employment category, or certain humanitarian programs. The exact requirements depend on the immigration category and individual circumstances. Another question involves the effect of filing a lawsuit if the case is not successful. In most immigration litigation, the purpose of the lawsuit is to ask the court to require the government to take an action, such as making a decision on a case, or to challenge a policy believed to be unlawful. If a lawsuit is unsuccessful, it usually does not change the underlying facts of the immigration case, which are evaluated based on the evidence submitted to the government. Someone asked whether a green card holder who has applied for citizenship can still travel. In many situations, travel is still possible, as long as the individual does not have issues such as criminal history or pending removal proceedings that could affect re-entry. However, travelers should always review their individual circumstances before leaving the United States. Another important point relates to conditional green cards. Individuals who receive a 2-year conditional green card through marriage must file a petition to remove conditions before the card expires. If the petition is not filed within the required time period, the individual may lose permanent resident status. It is important to work with a qualified professional to complete that process correctly. Someone asked whether asylum applicants can travel within the United States. Domestic travel is generally possible, but individuals should always carry valid identification and understand that travel carries some level of risk depending on immigration status. Finally, thank you all for being here today and for participating in this discussion. If you would like to schedule a consultation, you can reach us at McBean Law by calling 914-898-9488. You can also visit our website to request a meeting. We are available to meet with clients in person, by phone, or through Zoom. Don't forget to watch our latest YouTube video about what to do if your case is denied by USCIS. Also remember that March 14th is the deadline to join our immigrant visa lawsuit for the affected countries, and our naturalization webinar will take place this Friday. Registration links will be shared in our stories and on our website. Thank you again for joining today's session. I appreciate your time and your thoughtful questions, and I look forward to seeing you in the next discussion.